Madam, Ms. Silverlim said that the regulatory powers introduced in this bill, in particular at Part 6A, give MND too much power to intervene or even interfere in the affairs of town councils. Allow me to reiterate the following key points. The proposed amendments do not fundamentally alter the character of town councils or their roles or functions. Under the revised Act, town councils will continue to enjoy broad autonomy and be empowered to run their estates as they have been for the past 28 years. But these powers are not and should not be unfettered. Town councils will continue to exercise autonomy to run their estates, but within broad rules laid down to ensure proper governance and to safeguard the public interest. Autonomy does not give anyone a blank check to run down the town council or the estate, misuse funds, mismanage the system, or break clearly established rules. The bill simply provides clarity on some of the existing boundaries within which town councils operate. For instance, town councils being subordinate to public laws and statutory authorities carrying out statutory duties. These minimize ambiguity on the ground. The bill also puts in place safeguards and compliance mechanisms to enable MND as a regulator, as it has always been, to exercise more effective oversight of town councils on residents' behalf. In fact, some of the provisions in the bill enhance the direct accountability that town councils are premised on, accountability to residents and voters. For example, the bill requires town councils to publish their key appointments and financial statements. Town councils are also required to keep long-term projections so that they have an honest opinion as to whether their management style is for the short term or is for the long haul. And unless the situation is so dire that the health or safety of residents is at risk, MND will not step in to the shoes of the town councils who should do as they are obliged to do. Madam, Ms. Silverlim expressed concern about the independence of MND, in fact, the appropriateness and independence of MND as a regulator for town councils. She says the new enforcement powers of the Town Councils Act are too wide-ranging and may be wielded as a political tool because the head of the ministry is a political office holder. These are serious allegations, quite unwarranted, and perhaps are indicative of the worldview from which the Workers' Party comes from. That when a political entity and a politician gets into power, there is no trust in his integrity, there is no trust in the voter. He must be checked, fettered, locked up, chained, that you need ombudsmen for every aspect of his work, especially when it relates to issues that may pertain to the politics of the land. First, let us all go back to fundamentals, and Mr. Singh and Ms. Lim are both lawyers and will understand this. When a government is elected by the people, political office holders will helm the executive arm and be responsible for all the ministries and agencies, including those that have law enforcement, regulatory and licensing powers, the police, the National Environment Agency, CPIB, IRAS, and so on. And we are not unique in that sense. We are not a unique system to do this. And with a parliamentary majority, government can and is obliged to make laws in the public interest. But madam, these powers and the laws that are made have to be used judiciously, fairly, justifiably, and even-handedly. In the case of the Town Councils Act, they have to be applied across all town councils, regardless of political affiliation. Some members have spoken about how the town councils have been fined. Some other town councils have been censured, embarrassed by agencies when they announce what has happened in the media. Even the Prime Minister's Town Council, when allegations were made, they took the first step to make a report, and now CBIB is investigating Ang Mo Kio Town Council. Is there an allegation or claim that the officers of the CPIB will fear investigating Ang Mo Kio Town Council? Are they timorous souls? I fear that allegation goes a bit too far. Because these powers, madam, are derived from the people and given with their trust and confidence, trust and confidence are fragile things. There is no sweeping of things under the carpet. Our history has shown that this government, this party, will act against wrongdoing, will not sweep things under the carpet. The recent Ang Mo Kio Town Council case is a case in point. In the event of a conflict of interest, there are established and appropriate ways to deal with it. In the case of a Town Council Act, if the minister is required to recuse himself, then the other office holders will have to step up and exercise those powers with the same good faith and with the same obligations as the minister. And if all the officials or the MND POHs have to be recused, then some other minister will have to be appointed to exercise those powers. If these powers are used in an unjustifiable manner for whatever reason, public trust will be seriously eroded. We can certainly count on members of the opposition acting as sentinels to make allegations ever now and so often, pointing to shadows, claiming conspiracies. Madam, where prosecutions are instituted, as is envisioned possibly under the Town Councils Act, where there's wrongdoing, there is also the Office of the Public Prosecutor, who decides if charges should be filed, and the judiciary, who decides if these should stand. Mr. Singh and Ms. Lim call for the appointment of independent persons. Ms. Lim mentions independent ombudsman. Ms. Sylvia Lim mentioned ombudsman. No. Mr. Singh talked about independent auditor or accountant. But these so-called independent ombudsmen or independent accountants have to be appointed by somebody vested with the authority to take charge of the matter, somebody responsible for the policy of the issue. So will the allegations of bias and partisanship really ever end? What about office holders of other ministries and agencies who may be responsible for enforcement agencies or licensing agencies which might incidentally apply to town councils or to members of political parties, card-carrying members, or to vocal pro-opposition members? Does Ms. Lim then say you need to have one law and one system for the common man and an independent ombudsman for all these other people that she's identified? Or should we have one law of the land and one system for everybody under the rule of law, under the scrutiny of the eyes of people and the protection of the courts to ensure that the executive powers of the government are exercised fairly? Madam, let us look at what happened thus far for the AHTC saga, or AHPETC saga. The whistle was first blown by AHPETC's own external auditors in 2011. The subsequent audit was carried out by the Auditor General's Office, an independent audit office which Ms. Lim referred to in her speech. It made very serious findings about mismanagement, improper payments, conflict of interest, poor record keeping, and internal processes. Equally serious conclusions were drawn by the judiciary, both the High Court and the Court of Appeal, when the matter was brought to court in 2015. Pursuant to a court order, AHTC appointed KPMG, who came out with an independent report with serious allegations of possible civil and criminal liability. And now at HDB's request, firm request I may say so, and confirmed through a court order by the Court of Appeal, AHTC has delegated decision-making on recovery of losses and further action to an independent panel comprising Mr. Philip Jeyaratnam, Mr. N. Srinivasan, and Mr. Ong Pang Thai, 3 eminent professionals. With the amendments to the Town Councils Act, none of these avenues and options will be abrogated. I certainly hope Mr. Singh and Ms. Lim do not also dispute the fairness and independence of these platforms. In fact, for the purposes of compliance reviews and investigations, under the bill, MND can similarly appoint an independent auditor or independent panel as inspectors to carry out the review. These inspectors, as I've said in my opening speech, must report to both MND as regulator and the town council over whom the review or investigation is being carried out. In most instances, consistent with the political philosophy underlying town councils, we expect that the town council will, in a light touch scenario, on their own accord, resolve the issues identified by the inspectors promptly. If so, MND will not need to step in to issue any rectification order. But in any event, MND's rectification order can only reflect what the town council ought to have done in the first place, and will not require the town council to take any action over and above what is necessary to bring the town council into compliance with the Town Councils Act and its subsidiary legislation. Madam, in the Town Council's Amendment Bill, there is Section 43A on compliance reviews or health checks, and Section 43B on investigations. When an investigation needs to be carried out, MND is prepared to appoint independent auditors and professionals to carry out investigations, and they will then have to report both to MND and the Town Council as required by law. Having said all this, perhaps let us go back and ask, what really is AHTC's position on regulatory oversight? Is it, as I said earlier, a cynical fear that people who step up into politics and are elected by people into government are to be mistrusted, to be distrusted, that they will, in full glare of public, misuse laws? Or is it really the case that Ms. Lim is concerned about real problems being investigated by MND? But to really know what it is, let us look at what was said in court, recorded by court transcripts. This was when HDB sought the court's intervention in 2015 to appoint an independent auditor to look into AHTC's problems and to take necessary action. We wanted, or HDB applied for the court to oversee this, the court to appoint an auditor, and for this auditor to be an independent auditor, not reporting to HDB or MND, but reporting to court, acting professionally and independently. To our surprise, AHTC fought the application and tried to stop an independent auditor from being appointed by the Supreme Court of Singapore. Their lawyer argued explicitly in court with his client seated behind him on AHTC's behalf that even if there was mismanagement or misspent funds, their view was that there was nothing that could be done other than through the ballot box. So is it a willingness for appropriate, independent, fair, justifiable regulatory oversight? Or is there a preference for no oversight whatsoever? Madam, MND will and has always exercised its regulatory powers with due care and regard to people and the residents' public interests, as it has always done. Apart from the public's eye, there's always the recourse to the courts under the framework of judicial review. Ours is a system of rule of law, and any abuse of public powers is subject to the jurisdiction of the courts. And I'm sure Mr. Singh and Ms. Lim understand that very well.